but the rules forming the basis of the Schengen Acquis have also been expanded, with more and more areas of public life being regulated, and ever-expanding harmonization. It all started with police and judicial cooperation, and now we have a harmonized policy in external border protection. We have the same policy for residence permits, a uniform visa regime, etc. Secondly, the Union also prioritizes the implementation of international obligations by member states in the area of international protection under the Geneva Convention on Refugees of 1951 and the New York Protocol to that convention from 1967. Each country that is party to the convention must respect the principle of non-refoulement. Under this principle, which has been accepted for years as a rule in customary international law, we may not return a foreign national who has sought protection until we are satisfied that they would not be persecuted and their life, health, and freedom would not be in danger if they leave the country where they have sought protection. Under this principle, we are also bound to consider each and every application for protection with an individual approach. We are bound to grant the relevant type of protection if the person meets the legal criteria. Under that principle of non-refoulement, where there is no absolute evidence that the foreign national is entitled to protection, we must interpret that lack of evidence in their favor. All of these commitments often test national asylum systems and thus the Union as a whole. The third priority of the European Union is to secure the safety of the citizens of the EU. That means to secure public order, the national security of member states, and public health. The major question here is how do we strike a balance between the first two priorities on the one hand and the third one on the other hand? How can we guarantee the rights of EU citizens and persons seeking protection or otherwise legally residing in the Union, while at the same time safeguarding public order, national security, and public health? I see two potential ways forward for the European Union in terms of a solution. The first one is for individual member states at their own discretion, and obviously in line with any exemptions granted under the Schengen Acquis, to start closing their internal borders. This is now a trend in some member states. The issue with this route is that it does ensure the safety of nationals of that particular member state as well as of the foreign nationals residing there lawfully. However, other Union citizens would not be protected to the same extent. This means that this is an individual approach, whether everyone is left to fend for themselves. This would either provide a merely temporary and partial solution, or alternatively would give rise to negative trends which may leave the impression of an impending dissolution of the European Union. We should keep in mind that, as I already mentioned, the right to free movement is fundamental to the EU. This is its inherent characteristic that makes the Union a sui generis or unique alliance. Without freedom of movement, the Union would not be able to function, or at least not as Europeans today know it and have known it. It is also meaningful that the European Parliament too has defined freedom of movement as a key principle of the Union and insists that it be respected by all member states. As regards the Schengen Area, in its resolution of the 30th of May 2018 on the annual report on the functioning of the Schengen Area, Parliament has condemned the continued reintroduction of internal border controls, as it is fatal to the integrity of the Schengen Area and it is detrimental to the well-being of European citizens and to the principle of free movement. The second possible route or way for the Union to take in order to maintain a balance among the priorities I mentioned is to reinforce its external borders. If the flow of irregular migration were stemmed there, it would, of course, while respecting individual rights, it would enhance the security of all EU citizens in all member states, while simultaneously preserving the possibility of free movement within the Union. Here too, we are looking at two different options. The first option is for the European Union to take over control of the external borders using its authorities. There are two major issues with this approach. It would impose an enormous and permanent financial burden on the Union, and it would also violate the sovereignty of the countries constituting its external borders. The second, and in my opinion best option, is to use the principle of solidarity and for the EU to support and assist these countries in securing their external borders. Such support would be a temporary measure and would go in two directions. Financial and material support for member states for the technical aspects of border security, and enhancing human resources capacity by training both relevant staff and future trainers from these countries. This option is also in line with existing applicable EU law. For example, Article 17 of Regulation 2016-339 on the Schengen Border Code, and with all its amendments, the latest one being from July, refers to operational cooperation among member states coordinated by Frontex, but not controlled or directed by Frontex. Similarly, under Article 42 from Regulation 1896 from 2019, the European Border and Coast Guard Agency functions primarily as a supporting authority, and only when the control of external borders becomes ineffective to such an extent that there is a risk of jeopardizing the functioning of the Schengen area, and only following a Council decision may Frontex come out with binding acts and take over the member state authorization to act in this area. Since I am out of time now, I'd like to say the following. You hold the future of the Schengen area in your hands, and I would like to call upon you to really look into it very carefully and very seriously. Thank you very much for your attention.
Thank you, Professor Georgieva Atanasova. And now we move to our next speaker, discussing the presentation on the revised Schengen Borders Code. We have with us Ms. Denise Kvantes from the Schengen and External Borders Unit of DG Home from the European Commission, and Ms. Kvantes was directly involved in all the negotiations on the new Schengen Borders Code, so we can't expect a better expert to talk on that topic. So, Madam, you have the floor.
Thank you, and thank you for that very kind introduction. Indeed, on the evening of the 6th of February 2024, the parliamentary rapporteur Sylvie Guillaume, the Belgian presidency, as represented by the minister Annelies Verlinden, and my commissioner at that time, Ylva Johansson, shook hands to sign that they had reached a political agreement on the amendment of the Schengen Borders Code. And this was, for me personally, a very important moment, but also, I think, politically, a very important moment. This agreement came after more than 2 years of negotiation on this proposal, but actually the work that had started already a long time before that. First, when we came up with a proposal in 2017 for an amendment of the Schengen Borders Code. This proposal was put forward at that time because we saw that more and more countries were reintroducing internal border controls in response to various challenges, such as the 2015 migration crisis, terrorist attacks. So it became clearer and clearer that the rules on internal border control were no longer up to the times. So this proposal from 2017 had as an objective to update the rules concerning the temporary reintroduction of internal border controls. However, on that proposal, despite general agreement by the stakeholders that there was a need to address the issue of the internal border controls, unfortunately the Parliament and the Council did not reach an agreement and became stuck in the negotiations. And unfortunately, we did not manage to reach agreement on that proposal. So when the previous commission, the first von der Leyen commission, took office at the end of 2019, one of the tasks that we got in my unit, a very important one, was to come up with a new proposal. To look at the things where agreement was reached on in the 2017 proposal and take these elements up again, but to try and think of new solutions for the points where the Council and the Parliament could not agree on. So we had just started the first reflections on this proposal early 2020 when, of course, I'm sure you all remember, a big event happened that had also a major impact on the functioning of the Schengen area, which was the COVID-19 pandemic. So it's becoming, fortunately, more and more a distant memory, but for me, these first days are still very fresh in my memory because it was very chaotic, with first one member state, then 2 and 3 member states reintroducing internal border controls in an attempt to stop the spreading of the virus. Until at the height of the pandemic, we had 18 member states that had internal border controls in place. And because these internal border controls were also combined with travel restrictions, this had a major impact on transport, on cross-border workers, especially also in cross-border regions, with, as a result, empty shelves in the supermarkets, employees unable to reach their place of employment, and people even unable to reach the nearest hospital in case where that happened to be in another member state. And even when member states started to lift these controls again, it was not always done in the best way, with neighboring member states lifting controls at different moments, one at the start of the day and one at the end of the day, leading to confusion at the internal borders and traffic jams. So it was very clear that any proposal for an amendment of the Schengen Borders Code that we would have to put forward would have to draw lessons learned from the pandemic. And then in 2021, a new phenomenon appeared at the EU's external borders, which also had a big impact on Schengen, which was the appearance of state-sponsored instrumentalization of migrants, in the beginning mainly by Belarus at the border with Poland and the Baltic states. Now, the Schengen Borders Code states that border control is in the interest not only of the member state at whose external borders it is carried out, but of all member states which have abolished internal border control. So also here it was clear that this issue would also have to be addressed in our proposal. So these were two very important external factors that happened during our preparation of the proposal for an amendment. Politically, our proposal was already announced in 2 important documents. The first one was the communication on migration and asylum, which was put forward in September 2020. And the second one was the so-called Schengen strategy, which we adopted in June of 2021. So to prepare the ground for our proposal and to get the widest possible input and support, we conducted a stakeholder consultation, which took place between November 2020 and February 2021. So we consulted various stakeholders, member states, the parliament, carriers, NGOs, etc. We also had a public consultation, which ran from January to March 2021. Where we got feedback mainly from EU citizens, but also from some non-EU citizens, businesses, public authorities, trade unions, and academic and research institutions. So all this input then fed into our impact assessment, which we submitted to the Regulatory Scrutiny Board in April of 2021. It received a positive opinion with some comments, but the most important thing was the outcome, which was that the preferred option for action was a mixed approach of a targeted amendment of the Schengen Borders Code combined with soft law. So this option was considered to best address the criticisms that we saw from citizens, the European Parliament and member states with regards to the long-lasting checks at internal borders. So then we really had to start writing the actual proposal, which we did in the months after that. And then finally, the proposal came out in December of 2021. So there are 6 main areas where we proposed changes to the Schengen Borders Code. And the first 2 concern the external borders. The first one was in response to COVID-19, where we had actually no mechanism whatsoever to impose travel restrictions at the EU external borders in a harmonized way. So during the COVID-19 pandemic, we had to really come up with everything from scratch, start coming up with new ideas, and we did this mainly by means of council recommendations, which then led to a list of countries, third countries, where people were either allowed or not allowed to enter the EU. We did not want to have a same haphazard approach in case we would ever have to face a new pandemic. So we proposed a mechanism already in the Schengen Borders Code where a council regulation would then state the travel restrictions that would have to be implemented by the member states in a harmonized way. And the second one was in response to the instrumentalization of migrants, where we proposed a definition of instrumentalization as well as some provisions on border surveillance in case member states were confronted with cases of instrumentalization at their external borders. The other 4 areas concerned the internal borders. So again, in response to COVID-19, we proposed a so-called contingency planning for the Schengen area in case of a threat affecting several member states at the same time. So this could be COVID-19 kind of situation or any other kind of threat that would affect member states in a similar way. So in that case, our idea was that the Council would come up with an implementing decision which then proposed a harmonized approach to the reintroduction of internal border controls, trying to prevent the situation that we had during COVID-19 where everything was done in a very chaotic way. We also proposed some procedural safeguards in case of a unilateral reintroduction of internal border controls. So the Schengen Borders Code does give member states the right to reintroduce internal border controls in case of a threat affecting their internal security or public policy. But the idea was that the longer this internal border controls would last, the stricter the requirements are for proving that the necessity and proportionality of these checks are really carried out. Then the third area was that we proposed mitigating measures and specific safeguards for cross-border regions in case where internal border controls were reintroduced, because we saw specifically during COVID-19 pandemic that it was really the cross-border regions that were suffering the most. And then finally, and maybe most importantly, was we proposed an increased use of alternative measures to address threats to member states' internal security or public policy. The idea there is that by increasing the alternatives to internal border control, a member state would not have to necessarily resort to internal border controls anymore. So we did that by clarifying the more extensive use of checks in internal border areas other than border controls, and it also proposed the so-called transfer procedure, where migrants could be transferred from one member state to another in case of cross-border police cooperation between 2 member states. So negotiations on the proposal started in the Council under the French presidency, and for them this was a clear priority. And because of that, a general approach was reached already within 6 months in June 2022. So the Parliament took a bit longer, but adopted its report in autumn 23, and then we could start with the trilogues. This was under the Spanish presidency at that time, and I'm sure the Spanish presidency would agree with me when I say that even though for them it was an important file, for them the clear priority was to reach agreement on the Pact on Asylum and Migration, which they managed at the end of 23. Which meant that it was then up to the Belgian presidency to conclude the trilogue. And as the legislative period was coming to an end, it was essential that we reached agreement by early February at the latest. So we were really under a clicking time. But because all the parties involved, the Commission, the Council, and certainly also the Parliament, were very committed to find solutions, as already mentioned, we managed to find this agreement on the 6th of February, which was for me a very nice end result of several years of work. So as in all negotiations, the end result was, of course, a compromise, which meant that for all parties, probably they did not get fully what they wanted, but I think from the Commission side, we were overall quite happy. For instance, we would have preferred this contingency planning for Schengen to be in cases for all kinds of threats affecting member states, but in the end it was decided that it would only be limited to public health emergencies only. But still, I think it's very important that we have now something in case a future pandemic would unfortunately arrive at the EU. Take this very seriously from our side, and I think my Deputy Director General will explain later where we are at this stage. Thank you very much for your attention.
Thank you, Madam Quantas, for your remarks. And now we move to the interventions and questions and answers part of our discussion. We will start with the first round. I will collect all the questions, and then our speakers will have time to reflect. And after that, we will see whether we have time or not for the second round. So I'll really encourage everybody to be brief, to stay within 2 minutes limit. And we start with EPP. Anybody want taking floor on behalf of? Okay, as there is. Mr. Armand, please, you have the floor.
Ja, vielen Dank, Frau Vorsitzende. Ich wohne.
Thank you very much. I live in a border area. I'm a child of the Schengen border area. And in the COVID times, I was constantly saying that I was calling out what was being done in the context of COVID policy, because all kinds of border closures were being imposed and they were not actually in line with the law. Now the code has of course been reformed a bit. I would have preferred to see a more extensive reform in the final format, but nevertheless it's a big improvement on the situation that we had. And I think that my experience as a citizen of a border area is not unique, because there are many, many border checks in a lot of border areas. There's one right outside my house, basically, because I cross the border immediately, and there is a border check, which hadn't been the case for years and years. And I'm far from alone. I know this. So it's a very important principle, which is proportionality. There's another one, which is necessity. These are defined in the Schengen Code. And if you talk to the police, they will say that for the first couple of months, they think that the border checks do actually have an effect, because everybody knows that controls will be imposed. They're actually going to happen, and some they will either take a different route or they won't travel. But after that, the effect rather dwindles. So the question is, what about the efficacy of the border controls? And how can you ensure that they are actually in line with European law? Because there are certainly cases, a number of them, where this is not the case. Thank you.
The group, I will invite Mr. Lopez Aguilar to take the floor.
Thank you, Chair. No surprise, there will be a coincidence in the concern that is to be expressed by most of us, which are well aware that Schengen used to be the big thing of the European experience. Schengen meaning a fundamental right, free movement, the most gratifying and appreciated fundamental right of all for the European citizens, according to every poll. So the thing is that Schengen has been shaken, if not sliced into pieces or downgraded severely, not only through the pandemic and after the pandemic, but just as we speak now, 10 member states have resorted to the last resort, which is contemplated in the Schengen Borders Code. Last resort, with no proportionality, with no necessity assessed, only for the sake of security, just not even specific considerations of public security or public order, which are the exemptions that are contemplated in the wording of the Schengen Borders Code. So my question is just naturally related to the Commission. Is the Commission willing to actually take seriously the work that we have crafted so heavily in the piece of legislation that we updated the past mandate of the European Parliament, ready to initiate infringement procedures against those member states which have not actually justified temporary suspensions of Schengen in order to secure precisely the proper implementation of the Schengen Borders Code and make sure that it's last resort, proportionality, necessity, and justified, and of course, temporarily framed. They are not beyond definition. That they have a clear time frame as to the exemption, because it's not easy to understand that at least 10 member states have notified the European Commission temporary introduction of border controls, including the bigger ones, including the founding ones, including Germany. So it must be taken seriously. We had a lot of work in updating the Schengen Borders Code. It shouldn't be in vain. It should be taken seriously. Thank you.
Thank you. On behalf of the PFE, I would give floor to Mr. Buxada. Please, you have the floor.
Muchas gracias, presidente.
Thank you very much, Madam Chair. And thank you very much to the two previous speakers. And it's a scandal that a few days after that mother and child were killed in Munich by the false Afghan refugee, to hear what we've just heard, the two speakers have clearly laid out that the Schengen Code and internal freedom in Europe are undermined because external borders are not protected. Denmark, France, Sweden, Austria, Germany, and a whole list of others. For you, all those governments are wrong. Mr. López Aguilar say that there are no motives of public security, where all justifications are either illegal migration or the risk of terrorist attacks. And those exist. There are such attacks every week in Europe, every week. And they have done it for this reason. Those member states whose borders are external borders of the Union, because they can't or won't protect their borders. And that's why they're doing what they're doing. And that's why we've had this within Eurodac to control borders internally. But all of this is a fact. It is a fact that if we do not protect the external borders of the member states, then of course we will have to protect the internal ones. And all of this comes from a petition, and the petitioners are right. It's not a good thing that these internal borders be closed. Of course it's not a good thing. But the responsibility is that of the external countries. And when we're sanctioning Hungary, which wants to protect external borders, and we congratulate Pedro Sánchez, who has left more than 40,000 illegal immigrants through in the Canaries every year, who reach Madrid in 24 hours without knowing where they're coming from, what is their intention, who they are, without any documents, no passports, and 12 hours later they can be in Brussels, Berlin or Paris. When we do this, we are running a huge risk. And this is the reality before us. Instead of attacking the member states who are trying to protect the security of their citizens, we should try and find measures to really control our external borders and carry out the expulsion of all those who have entered European territory illegally. Thank you very much. I have nothing to say about what the speakers have said because I agree with what they've said.
Thank you. And on behalf of ECR, I give floor to Madam Wisniewska. Would you like to take floor? There are no other speakers on behalf of your group.
I want to take...
In the second panel?
Second panel, yes.
Okay, then we move further to the Renew group. Is there anybody who would like to speak on behalf of Renew? No? Then Madam Strick from the Greens, you have the floor.
Thank you. Thank you very much. Indeed, thanks a lot to the speakers for their presentation and overview regarding the Commission, the revision of the Schengen Code. Indeed, as Mrs. Quantas said, one of the reasons was, of course, the permanent internal border controls and the lack of the threat to the free movement area. But as my colleagues also said, we still see this practice of permanent border controls. We see actually an increase of the number of internal border controls. So the question is actually, to what extent does the revised Schengen Border Code help us in order to put this to a halt and to enforce better? Also because I mean, the grounds may have been becoming broader, but we still need a proper justification. And it's my clear understanding that this is still often lacking. Furthermore, we still hear more and more cases of pushbacks at the internal borders from asylum seekers, which is also not in compliance with the revised Schengen Border Code. We also see actually new proposals, like in Germany, to make that standard practice. What will the Commission do against this? Because I think it may undermine the whole pact. Then also we have this possibility of police checks after the border in order indeed to prevent internal border controls. During the negotiations, there was a clear expression of the risk that it might lead to ethnic profiling. What does the Commission know about how these police checks are being conducted, and is there any monitor mechanism, or what does the Commission know about if this risk is being realized? And my question to Professor Georgieva Atanasova, she she mentioned the option of maybe empowering Frontex at the external border controls. This is a very interesting idea, also quite revolutionary, because the current regulation doesn't allow for that. But does the professor see any possibility to, within the current legal framework, already give Frontex more possibilities to steer or to instruct, for instance, also through the operational plans that need to be negotiated with the member states, and also the possibility that Frontex has to put assets, to finance assets or not? Thank you.
Thank you. And on behalf of the left, Mr. Kramer, would you like to speak? Yes, please. You have the floor.
Merci, Madame la...
Thank you, Madam Chair. I think that today Europe is suffering from great ill, and that is that the Commission never engages in infringement procedures when a member state doesn't follow EU law. For 10 years, France has reinstated controls on its border with Italy in Menton and Montgenèvre with different pretexts. It was terrorist attacks in 2015, then it was the Rugby World Cup, and then the Olympics, and now, once again, it's migration. And every time, the Commission gave the green lights. So I can't see what could happen, no matter which text is adopted by Parliament and Council. I don't see how we could make things move in the right direction. So either we look into actually reinstating borders and we stop beating around the bush, because we can't trust our neighbours, and also because we don't trust Frontex, because ultimately the external borders are monitored by Frontex, and it's very costly for the European taxpayer today. So either we simply decide to save that money and decide member states to reinstate full border controls, which would be a step back in terms of what the EU should be today. Sorry, that's not really a question I wanted to raise, but I wanted to make this point and say that the Commission should really carry out the necessary measures when member states do not abide by EU law.
Thank you, colleagues. And now I turn back to our speakers. You heard the interventions, you heard the comments, you heard the questions. So I will give you both floor for about 5 minutes to reflect on where you want to comment or where you want to answer the question. And I will start with Professor Georgieva Atanasova, if the professor is still with us. doesn't seem to be the... Yes, yes. So, Professor, please, you heard the interventions, you heard the questions. Please, you have 5 minutes to reflect.
Благодаря ви. Първо бих могла и бих си позволила.
Thank you. I will put together the first two questions. They were about the internal borders controls, whether they are in line with the Schengen border code, and whether there should be an infringement of the principle of proportionality. The procedures, as put forward in the Schengen Code, should be complied with. Therefore, I linked these two questions into one and tried to give an answer to both questions. Principles should be at the forefront of implementing any act such as the Schengen Border Code. If the principles are violated, the very legislative act is violated. So any action taken by a state on its internal or external borders and their protection should be in line with the principles in the common interest, to abide by the rules, to observe the rights of the people who may be affected, both legal entities and others. The principle of proportionality must be complied with. So when there is a violation of the principle of proportionality, this should be treated as violation of the code itself, and the actions taken by the member states should be considered not in compliance with the law. Of course, this is my personal opinion. There are competent authorities that would say whether this indeed is the case, whether the principle of proportionality was respected or not, and to decide what action should be taken vis-à-vis a closure and whether such a closure of a border is legitimate or not. There was a direct question to me concerning the powers of Frontex. Maybe I was not correctly understood here. Perhaps I did not express myself correctly. What I said was not that Frontex should take over the management of the borders. No, for me, the external border should be protected in the common interest by the member states that have that external border of the Union. As to operational plans that can be applied together with the states, you know that the procedure is more complicated. The opinions of other authorities has to be taken into account, for instance, that of the Council. And there are limited cases where this can be applied. This is provided for in the regulation. So they apply only in exceptional circumstances. As to funding, there is a legal framework which directly relates to funding the management of EU's external borders, and there are mechanisms provided for. I mentioned in my initial statement that material should be provided, such as buildings, equipment, so countries should get the assistance when they need such an assistance. Also, human resources have to be strengthened. The human factor is of exceptional importance. Technologies alone at this phase cannot ensure the security in such a manner that along with the security we can protect the rights and freedoms we want so much and which are characteristic feature of the EU. Thank you very much.
Thank you, Professor. And now I would like to give floor to Madame Kvantes to reflect on the questions and interventions.
Yes, thank you. With regard to the intervention of Mr. Arimont, we have addressed the COVID-19 pandemic in our amendment of the Schengen Borders Code, but not only there. We also have extensive experience from that period that is not necessarily reflected in the Schengen Borders Code, but is still there in case we ever need it. For instance, there was the initiative of the green lanes, whereby in case of reintroduction of internal border control, transport operators should be able to pass the internal borders within 15 minutes to prevent that they get stuck in traffic jams. We have lists of what we consider as essential functions, so people that really should be able to cross the border even in cases of pandemic. So we still have a lot of experience there that we could use again as well, that is not necessarily in the Schengen Borders Code, but more the soft law kind of initiatives. And with regard to the efficacy of internal border controls in case of a pandemic, we had extensive video conferences at that time where indeed the evidence of the efficiency of border controls in such cases was considered to be fairly limited. Only in the extreme early stages and in cases of extreme border closure, maybe in that case, viruses could be prevented from spreading, but I think that is just not a realistic scenario within the EU. I mean, maybe only works for cases like North Korea. With regard to Mr. Lopez Aguilar and also Ms. Strick and Mr. Karem on the fact that we do have still a lot of countries with internal border controls in place. Yes, this is true. I think here I have to highlight that the amendment of the Schengen Borders Code only entered into force in July of last year. So as I mentioned, we're still working on the implementation. This will take time. We also have to convince the member states that the alternative measures that we have in place are much better to address problems such as irregular migration instead of just checking all kinds of legitimate travelers at the internal borders. But my boss will explain you more about that in the next panel as well. With regard to Mr. Buxade on the protection of the external borders, so my unit is responsible for Schengen and external borders. So I could also talk about the protection of the EU external borders, but in this case I was asked to talk about the amendment of the Schengen Borders Code, but I'm very happy to come back at another time and to talk about the EU external border protection, because I think we are doing a lot there as well from Commission side and Member States and Frontex as well. With regard to Ms. Strick's other questions, with regard to pushbacks at the internal borders, this is for us indeed a very serious issue should it occur. For us it is very important that in cases of refusal at the internal borders, the relevant provisions of Dublin and the Return Directive are still respected. So this is something that we underline in all our discussions with member states. And with regard to ethnic profiling, as in all provisions of the Schengen Borders Code, the respect of fundamental rights is of course very relevant, and this has to be done also in case of, for instance, the transfer procedure. I think maybe just to stress that the screening regulation will enter into force in mid-2026, which would also then apply for screening within the territory. So in cases of police checks where irregular migrants would be detected and they would then enter in the screening, they would fall under the provisions of this independent monitoring mechanism. And then finally, it was not really addressed to me, but the issue of Frontex at the internal borders. Frontex has a standing corps of border guards, and border guards can only do border checks. So for us, this would be kind of an incentive of reintroducing internal border controls, which is of course not what we want. So for us, Frontex at the internal borders is not an area that we're exploring. Thank you very much.
Thank you. And yes, for the second round, just quick questions. If anybody else, I do not see. So on behalf of S&D, Madam Sippel, please, you have the floor.
Thank you very much. Just a small remark to the last answer that we got. It's true that the latest changes of the Schengen Code only came into place lately, but even before that, we saw lengthy internal border controls without a proper reaction from the Commission, I'm sorry to say. So they have taken place for years and never there was any reaction. So I would like to see more clarity now. I also would like to underline that the Schengen area is so important that we should avoid everything to destroy this system. And it's not only important for industry and our economy overall. I think it's a big, big success regarding European Union and our citizens, because over the past years we have seen that more and more of our citizens are crossing an internal border regularly, many of them even on a daily basis, which is a good thing to bring people closer together. And I think we should avoid everything that again is putting people against each other. And therefore I think the best thing we can do is to protect the Schengen area without having regularly internal border checks in the Schengen area. And only one sentence on external borders. I fully agree that border controls need to be there, but that should never end up in closing our borders. That's just a remark on that. Thank you.
Madam Strick-Two-Finger.
A very small question about enforcement, because of course with the new Schengen Border Code, with the revision, the deadlines started to recount again, but now we have this prolongation by Germany. And as far as I understand the revised Schengen Border Code, the Commission must come up with an opinion if it has concerns about proportionality or necessity. So what will happen now regarding this prolongation?
Thank you. And Madam Quantas, would you like to reflect on what was said?
Just to say that I totally agree with whatever Ms. Sippel said. And with regard to Ms. Strick, yes, indeed, we have to come up with an opinion, not only if we have doubts on the necessity of the proportionality, but we always have to come up with an opinion in case we receive a prolongation of internal border calls leading up to a period of 12 months. So indeed, we received a notification from Germany and we will come up with an opinion. I can only not say at this time when exactly that will be. Thank you.
Thank you. And I would like to thank our speakers. I would like to thank all the colleagues for a very rich and useful discussion. I would like also to welcome to the discussion Madame Dupont, the chairwoman of the working group on Schengen and border scrutiny. And with that, we conclude our first panel. And in a couple of minutes, we will start. You want to start immediately? Okay. If everybody's happy, we can start immediately with the second panel. So the second panel, the hearing is about implementation of the new measures and instruments. We have again two speakers. And we will start with Mr. Sergio Carrera, who is Senior Research Fellow and Head of Justice and Home Affairs Unit in the Center for European Policy Studies. He will speak about the assessment of the current state of play of the Schengen area, strengths and weaknesses, enlargement of the Schengen area, also the cost of non-Schengen. And Mr. Carrera, you have 10 minutes for your presentation.
Thank you very much for your introduction, very kind introduction, and for the invitation to be allowed to speak in this hearing. My presentation is indeed based on research, academic research that we did in the context of a study that was commissioned by DG IPOL of the European Parliament. And I will present the key findings of the study, particularly focusing on internal border controls and the reintroduction of internal border controls. In the study, we started by highlighting how unique the Schengen system is in the world in terms of ensuring a professionalized system of how border controls and surveillance are supposed to be taking place, and a highly professionalized system going hand to hand with the rule of law and EU treaty principles. So these two really going hand to hand, and also ensuring EU-led supervision. So also a system where the European Commission, the European Parliament also follow very closely, can follow very closely the practices of member states. So this very unique system still is subject to a number of challenges that in the study we have identified, starting with, it has been mentioned in the comments and in the conversation before, a systemic lack of compliance by some member states, governments, of the rules. And in the study we posed the question, why is it the area of Schengen conceived or framed as different from the rule of law, in the sense of how member states comply with the rule of law when implementing Schengen? Are they doing this in their practices? Because it is true that since 2015, there have been 6 governments, member states, that have unlawfully reintroduced internal border controls in the name of different grounds beyond the remits and time periods that were foreseen in the Schengen Borders Code. And without really justifying the novelty of the grounds, justifying or rationalizing those controls. And the Court of Justice here has enacted a number of judgments that are extremely crucial when interpreting the Schengen Borders Code, including the need for member countries and governments to provide reasons as to these grounds, the extent to which they are new. They are truly new and distinct from the phenomenon initially identified. Much has been discussed, I've also witnessed, about questions of necessity, proportionality. Our study highlights the lack of evidence, actual evidence that substantiates not only the need for those controls, but the actual utility of these controls to face the phenomena that member states are notifying in their letters to the European Commission and the Council and Parliament. Particularly this linkage between asylum and internal border controls. The study highlights as particularly worrying. If one reads the latest notification by the German authorities, the key ground for reintroducing internal border controls is asylum. Reading the notification saying situations of homelessness, limited capacities of the authorities responsible for asylum. So why is a border policy needed when the phenomenon is asylum and reception conditions? If the issue is reception conditions, they need to invest more on procedures, on reception. Why is a border control necessary? And is it capable of meeting the challenge? And also, it's been mentioned in the German notification, we've witnessed these elements, individuals, and let's remember this, individuals committing acts of violence is mentioned in the letter. And yet, do these individuals represent entire populations? Clearly not. We are also seeing other examples of people from Syria actually taking action against people from the same country and not agreeing at all. So why entire populations are being considered as quasi-criminal is an issue of worry as well in the notification. Now, the Court of Justice here has also been very clear. In the case MA versus Lithuania of 2022, generalized assumptions or considerations about threats are not enough to substantiate that there is a sufficiently serious threat. It cannot be based on general threats and assumptions, otherwise those borders will become permanent forever. Instead, the court is asking for an individualized assessment based on objective and substantive grounds for those controls to be legitimate. And yet, it has been mentioned, our study finds an enforcement gap. There has been an enforcement gap at EU level. For so many years, impunity has been the conclusion. It has normalized this practice. Even if the Luxembourg Court, the Court of Auditors, this European Parliament, civil society have called the Commission to play the role of guarantor of the treaties. and also frame the conversation on asylum through a rule of law approach and bring infringement proceedings when needed. Even the possibility to accelerate those infringement proceedings when Schengen integrity is at stake, as is the case. Now, diplomacy has been mentioned. In the study, we identify a number of tools that have been developed that focus on Schengen diplomacy, finding political solutions with member states, but we question the effectiveness of these tools in light of the reality that member states are still not complying with the law. And if that's the key issue, if member states do not comply with the law, what should be the response? Well, the treaties tell us very clearly. The treaties tell us the Commission should bring infringement, and if those member states do not align, bring them to before the Court of Justice. It has been mentioned the 2024 amendments of the Code that run the risk of ad hoc legalization of malpractices, saying now we can continue. A malpractice that was illegal before the amendment was in fact adopted. So again, what is the impression that is being given to these governments in this regard? However, it's true that when one reads the new regulation, still member states need to substantiate, need to provide very clear evidence on the necessity, on the impact, increasing burden of proof, because otherwise, we close the shop. If the arguments that many countries are currently using in terms of serious crime and so forth is accepted, then temporary internal border controls will become permanent. It's as simple as that. In terms of alternatives, that the Commission also mentions and is now envisaged in the 2024 revision, police checks in internal border areas, it has been mentioned. Our study raises the issue of the risk of racial profiling and discrimination in police identity checks. Who is checked? Who looks like the threat? And the evidence tells us that it's often racialized communities. And in fact, in the Netherlands, there was a ruling back in 2023 by the Dutch Court of Appeal against the Royal Netherlands Marechaussee, confirming this, that internal police checks in border areas target the same people who look different. It's people who have nothing to do with citizenship. It's simply people who look different. Why them? Now, this makes us think, what lays behind these policies? And the compatibility of who is checked, or who do we have in mind, with the EU Anti-Racism Action Plan. The EU Anti-Racism Action Plan. And the study calls for addressing this also. How do we have oversight mechanisms for police? Complaint tools, in police checks, in internal border controls, in internal border areas, so that people who have legitimate travel claim, if they're mistreated, how are they treated? Can they complain to the authorities? Very daily issue. So the study calls for a merited trust model in Schengen. Merited trust, not blind trust, in how member states comply with the rules. Clearly, after more than 10 years, 6 member states have not complied with the rules. Now we have new ones coming into the field. I was reading the Italian government notification. They say that they reintroduce internal border checks with Slovenia, and I quote, they say the permanent presence of police personnel will be limited to major crossing points with targeted checks on individuals who, based on circumstances and facts, appear to pose higher risks to internal security, and or whose regular status within the Schengen area is doubtful. Who do they have in mind? How do those people look like? And yet, also here, is this a clear example of institutional xenophobia? Who is going to be targeted? The Schengen monitoring and evaluation mechanism, one proof of how unique and excellent an evaluation can be. Really well developed, very strong, and yet the study finds a missing gap between the findings of the Schengen evaluation mechanism and infringement proceedings. How do we understand the findings of the Schengen evaluation mechanism and launching infringements when member states simply don't comply with the rules? And we call for more monitoring and infringement clarity. It has been mentioned, last point, on independent monitoring. Very good, the screening, new screening regulation, but that the scope of the monitoring is limited. It's limited to the screening. It will not include, as far as I understand, pushbacks. It will not include the actual decision-making by the authorities. It will not include border surveillance activities. So in terms of the scope, it's a question for the Commission. How is this going to be ensured that the scope of this monitoring in the screening regulation is going to actually include all these elements? And my last point, just to conclude, cost of non-Schengen, the higher cost is one of legitimacy. The higher cost of what we are witnessing is one of legitimacy of the European Union as grounded in the treaties. If the Commission doesn't play this role of launching infringement proceedings and member states understand that they must comply with the law, we close the shop. Thank you.
Thank you, Mr. Carrera. And now I hand co-chairing back to Mr. Zonka.
Thank you so much, Madam Vice President. Thank you. Dziękuję bardzo. Proszę Państwa, wysłuchali...
Thank you so much. So we've heard our first expert, and now our second expert. This is Mr. Olivier Onidi, and I have the pleasure to give him the floor. You are the coordinator, Schengen coordinator in the European Commission, and you will present the topic, the reintroduction of border controls within the Schengen area, analysis of cases and consequences.
Oh, thank you very much for this, and thank you immensely for holding this hearing. I think it's a very important subject. Many of you have said it. While we will soon celebrate the 40th anniversary of Schengen, it is definitely, and we see it quasi every day, one of the most tangible and positive face of what the European Union and European integration can produce. But at the same time, it is indeed very important to note that nothing should be taken for granted. And clearly, we have seen a number of challenges in the way the overall Schengen is actually operating. Now, I would first start with some remarks that are meant to just underline the fact that while many point the fingers at some challenges and many of the weaknesses of the system, we still have a system in place that actually works and works pretty well. In terms, first, of overall governance, this has been significantly strengthened. This was something which basically was handled in the hands of experts and has now come to the political fore. European Parliament has increased its discussion, also its contributions related to Schengen. Schengen Scrutiny Board has been operating for a number of years. And finally, we managed at the Council level also to get the ministers in a situation to discuss on a regular basis Schengen, the way Schengen is operating, and collectively take also a number of measures in order to improve the overall functioning of Schengen. Second, despite the difficulties, despite the extremely difficult environment, we have seen Schengen grow. A few years ago, nobody would have believed that Schengen in the current context could actually be enlarged to a number of new member states. With Croatia, Romania and Bulgaria, we have the demonstration that this is still feasible. We're actively now working with the Cypriot authorities. Cyprus will be next in line to accede Schengen because Cyprus has a right to accede Schengen, provided, of course, the conditions are right. Third, a lot of emphasis has been put on the major identified deficiency of Schengen that was traditionally the vulnerabilities at the external borders. Immense increased and improvements have come. Is it through additional support? Frontex was cited a number of times, different also binding measures that apply at external borders, and also a number of systematic review, both in terms of the procedures that are in place, but also the systems that are actually used with the entry-exit system and others that are being developed. Fourth, the overall trust in Schengen is still there. Related to what my eminent academic neighbor has just presented, Schengen can only work based on trust. And this trust has been progressively reinforced in the sense that member states have agreed on a reinforced Schengen evaluation mechanism and also a number of additional ways to, on a regular basis, assess how individual member states are actually implementing their obligations related to Schengen. Now, the system is not perfect, and I, of course, concur with the fact that we have definitely a problem in terms of the traditional, now long-standing attempts of member states to reinstall and operate internal controls at internal borders. Now, here as well, the situation is not black and white. If there is one thing, it is that none of those controls are systematic controls. So you can duel on how member states actually produce and develop their risk assessments, how member states deploy the controls at different border segments, and how border officers or police officers actually decide on which car or which person be subject to a control, but at least this is being done on a non-systematic base, building up a number of tools that are being used traditionally by border guards and police also to try to capture the population, the traveling population, where they believe there is an increased risk. Second, we have seen, and I think we have put a lot of emphasis on this, we have seen throughout these years, it's true, some member states, 6 member states, have now internal border control regimes for 10 years. It's a long time. We all thought this would only be temporary. 10 years is really long. But we have seen in all contexts, including for those member states that have recently established such a regime of control, that everywhere there is a very, very strong development of so-called alternative measures. Hard border control measures being performed by a border guard is really still the exception. But we've seen that across and within the Schengen border, the Schengen area, a significant intake of additional police measures have been taken. And this is a very good signal, since we have lost a little bit the attention on the importance of the internal security. Everybody was only focusing on the on the external borders. This is not enough. We will definitely use and comply with the new rules agreed in the Schengen Border Code in order to challenge further member states on what is actually being done based on the regime of notified internal border controls, but also at the same time the demonstration of the necessity and proportionality of this. And if some aspects of the notifications, the recent notifications, are still either questionable or somewhat weak in terms of justification, here as well I would say that we have seen over the years an impressive improvements in the notification, the grounds being provided under these notifications, and also the exchange of information between member states and the Commission. This was very difficult in the old days. Member states, pleading on their sovereign right to do themselves the analysis, to take those decisions, were not very cooperative in terms of sharing information that sustain all the elements that are relevant for our analysis. We are now in a better position. So we are definitely in a position these days, and also comforted by very clear law that will bring us to formulate formal opinions on the different border control regimes being notified, and through these opinions not only assess the relevance of and the necessity of these regimes, but also look at how actually in terms of overall results one could achieve way better results in doing it in two different ways. And if we believe there is a legitimate need within the current Schengen zone to increase the overall police activities, there is for us indeed no need to do this at formal border crossing points. So that is a very, very important message that we will be conveying in the next State of Schengen report, with somewhat also of an analysis comparing the effectiveness of border measures being taken at border crossing points and alternative measures which are in border areas, police-related activities, which are basically also the ones that find the best tractions at the level of member states. So not everything is positive, but Schengen is there. Schengen is still there. And if there is also a reason why some member states might not have also totally renegated on their obligation towards Schengen, it is because they have this flexibility in order to cater for not only political but also concrete security-related issues which necessitate additional measures to be taken. Thank you, and sorry to be a bit long.
Również bardzo pięknie dziękujemy Państwu.
Thank you very much to our experts. And time for discussion, Q&A, 2 minutes for each group, political group. Mr. Lopez Aguilar. The floor is yours.
I'd like to show appreciation for the academic insight that was provided by Professor Carreras. But I have to add that it's actually shocking that we need to come up with an academic insight in order to realize that it was about completing the freedom of circulation of capitals, services, and goods with the freedom of circulation of people, which is a factor of legitimacy of the European experience, maybe the most powerful. And the consequence is only obvious. We could actually take the chance of having a Schengen Borders Code updated, a new regulation in place, in order to relaunch this very principle, because it seems necessary to remind the member states that freedom of movement of persons, people, within the internal borders of the European Union is a factor of legitimacy for the European Union. So I address a first question to Monsieur Onidi, representing here the European Commission, as to the viability and the opportunity of grabbing this chance in order to relaunch this most relevant principle, which we cherish so much. And the second point goes again to the Commission as to the consequence, which is also to be addressed, which is considering that it's obvious that member states are not suspending Schengen as a last resort, but as a kind of first reaction after every public opinion shook up, particularly, of course, situations that are to be seriously addressed. Certainly, security concerns are absolutely legitimate. But the point is that, is there any empiric evidence that every time a member state has resorted, not as a last resort, but as a first reaction to suspending Schengen, there is some security improvement? I mean, compare ourselves with giants in the global arena. The United States is a giant in the global arena. Would any security concern be addressed by suspending free movement between Texas and neighboring states of the Union? Would any security address be improved by suspending the communication between Vermont and Maine? No, that seems preposterous. Why shouldn't it be that the same preposterous in the European Union scale? Of course, security concerns are legitimate. They have to be taken seriously. But is there anything to do with an attempt in a certain member state with suspending Schengen? Is any security concern that is to be improved by suspending Schengen, with all of the damage that it takes, all the systemic damage that it takes to the European integration, to the European experience, and to European law, for one thing, which is binding for all the member states? It was binding 4 years ago, let alone say now, after all what has been going on in the European legal process, including Lisbon Treaty, the Charter of Fundamental Rights, which enshrines fundamental freedom of movement in Article 45.
Dziękuję bardzo.
Thank you very much. Madam Wiśniewska, the floor is yours. Thank you very much, Chair. Thank you to the European Commission, and thank you for giving us an opportunity to discuss this very important issue. I would like to focus on the situation related to Germany. Last week, the German government has once again extended controls on its borders for a period of 6 months. Controls on the border crossing points between Germany and Poland and the Czech Republic have been in force since 2023. In fact, we're facing a de facto removal of the Schengen area. This is a response to the ad hoc situation in Germany related to the migration crisis and the chaos in this country. In September last year, when Germany once again prolonged the suspension of the Schengen area, I asked the European Commission to tell me which article was invoked by Germany as a justification, and the Commission told me that Germany invoked terrorist threat, violence on the part of Islamic terrorists, and also the influence of all that upon the situation and security of German citizens. Once again, this situation has been upheld, and I would like to know what is the justification today. Can these issues be treated as this situation warranting last resort solutions? In the context of the Schengen Code, seeing that very many member states are having difficulties of that sort. For instance, Belgium. In Belgium, we are told about a new terrorist threat targeting Brussels and Antwerp. We hear that digital information, is being sent to the Arab world, encouraging them to ram cars into crowds of people, as has been done in Germany recently. We must understand that any suspension of the Schengen area has got a very strong impact on the economic situation of the neighboring countries, for instance, Poland and the Czech Republic. This is clearly runs counter to the principle of proportionality. I would like to ask the representative of the European Commission whether they are aware of the fact that the German government is maintaining border controls as a tool for domestic policy, and whether they are aware of the fact that perhaps this is a way of combating the results that have been engendered by the policy of Germany itself. Thank you. Thank you very much. Madam Cifrova will speak next.
Our talks here. I will sort of elaborate on what was said by Mr. Onidi. So we have 3 countries who ascended to Schengen: Croatia, Romania, and Bulgaria. And it's estimated by some estimates that Romania's GDP could increase by up to 2% in 2025 after ascending to the Schengen area. So I was wondering, and both, please, if you have anything to say on that, if you have any estimates on how much it would cost economically for the businesses if Schengen was non-existent, or if some of the controls that are temporary would become permanent, because we know that it's an economic cooperation as well. Some parts, I come from Slovakia. When we ascended Schengen, it helped the region of Slovakia, but also the Austrian part, which is close to the border on the western side of Slovakia. So if you have any economic estimates or any numbers that we can sort of envisage and see how the future of the businesses is taken into account in all of this. Thank you.
Bardzo dziękuję. 2 minutes.
Thank you so much.
Mr. Markart, The Greens.
Yes. Thanks a lot. Thanks a lot also for the presentation. I can keep it short. I can follow up on what Mr. Lopez Aguilar said. He asked for evidence on the security part, but I also have the feeling that there maybe is no evidence that internal border checks helping in the management of so-called irregular migration. So do you have any evidence that this reintroduction of border checks inside the internal borders of the European Union helps with managing of irregular migration? And then, to both of you. And secondly, Mr. Onidi said that the Schengen system is based on trust, and I somehow agree, but I think that the European Union is also based on trust in the European law. And if member states do not comply with the law for, as you said, 10 years, or maybe do not comply with the law, I ask myself somehow why the European Commission is not just asking a court to see if they comply with the European law or not. So I ask myself if there's kind of like a political pressure or political understanding to not ensure, for example, with sending the questions to the European Court that they can maybe see if they comply with the European law and the Schengen Borders Code or not.
Tak, dziękuję bardzo.
Thank you so much. Our next speaker, Madame Laurent.
Merci, Monsieur le Président, et merci.
Thank you, Chair, and thank you to the speakers for their presentations. I just wanted to pick up on what Mr. Carrera said, that I think, well, I entirely support, indeed. And I just want to paraphrase some of what you said. The Commission must be the guardian of the treaties, and I think that that is fundamental, and Schengen is part of that. And the very foundation of the European Union is free circulation of persons, and this is at the heart of our union and what it stands for. And also, I'd like to pick up on what you said about infringement procedures, which must be taken against member states that do not comply or go too far when it comes to carrying out internal border checks. I think that that's essential, and the Commission needs to pick up its responsibility with respect to this, and we need to see whether infringement procedures must be lodged. And if so, they should be. And I also wanted to draw your attention to what we understand here at Parliament, more or less implicitly, but increasingly explicitly, about internal border checks, which may take the shape of the construction of member states' protection facilities. And I think that in light of the European Union's history, that would be a fundamental mistake to do this. And this was also mentioned in the course of our discussions. On November 9th, 1989, we experienced the end of a dark period in European history. And I think that we mustn't backtrack to there. I think that that would be a very, very dangerous trap, both for the European Union as well as the member states. So, dear colleagues, I urge you to be vigilant and not continue to embark upon this backtracking. And it is fundamental that we can circulate freely, and we mustn't deprive us of our freedoms. Thank you.
Bardzo dziękuję.
Thank you very much to all the MEPs for your questions, and I will give the floor to our experts now. Yes.
Madam Sipel, bardzo proszę.
Possible. Thank you very much. I will talk in German, if that's possible. Ich möchte auf einige Punkte eingehen, die hier angesprochen worden sind.
Thanks. I'd like to take up a few of the points that have been raised by various participants, because Schengen is always linked to migration, invariably. And we heard that even in the first panel on the historical overview. So I'd like to take you back a bit to when in the past we were talking about a migration crisis in 2016, for example. Now, this is not the case. We knew, or at least we should have known, that a number of things were going to conspire, events were going to conspire and result in a lot of people moving to Europe. Therefore, it wasn't just the fact that people saw on the TV and elsewhere lots of flows of migrants coming to Europe as refugees. There were other factors at play. We do need to think carefully about this. Whether people are born in Syria or Afghanistan or Spain or Morocco or wherever else doesn't determine whether I'm a good person or otherwise, or whether I may have temptation to become involved in criminal activity or not. You could hear the discourse in Germany all too clearly. We really have had attacks in Germany, which you can count on the fingers of two hands a couple of times over. I'm not saying that if you have 20 or so attacks, that they're not each tragic and horrendous. But when you have 20 or so attacks, this does not mean that every single person from the country of origin of this particular perpetrator should be the victim of an absolute witch hunt. And this is honestly what is happening. Therefore, we have got to stand up and be counted. The consequences of migration and Schengen have got to be kept completely separate, because otherwise we're playing into the hands of the populists. This is what's actually happening. And if we continue down that path, we're going the absolutely diametrically opposed way to any roadmap that would take us to a future based on freedom and security. We need, yes, to have controls on our external borders. We need to do that in a robust way. We need to focus on Frontex and make sure that they can protect us against drug and arms trafficking and other criminal activity, organised or otherwise. But many people from Afghan and Syria are legitimate refugees and migrants coming to our country, and above all, we do not need to be protected against them.
Thank you very much. I do not see any other speakers, so now I will give the floor to our speakers. As you wish, who would like to start first? I give you the floor.
Thank you very much for all the comments and the questions. Starting with the last one, perhaps it is a very important issue, how an exceptional situation, as laid down in the code, is actually assessed. What qualifies as an exceptional situation, and even more so, a major exceptional situation? How the Commission assesses precisely what are the criteria to establish this exceptionality. Then on questions of free movement that has been mentioned in some of the comments, of course crucial, elements of right to asylum. So many of the people or the movements that are being labeled as irregular migration are in fact asylum seekers and refugees. So again, if this is an asylum policy issue, how does a border control help? When questioned similarly to criminal activities, how does a border check or a border control help to prevent? That's a very straightforward question, and yet, legally speaking, it's crucial because the Luxembourg court has said, mindful of the treaties enshrining a free movement area, how important that is to justify, based on objective data and grounds. Otherwise, those borders become permanent. I mean, 10 years. What a in terms of time. I mean, this sounds like a pretty long period, becoming quasi-permanent. So how do we? How is this precisely assessed? Is indeed a question of major importance. Infringements. We checked in our assessment, in our study, very difficult to find information on not even in this pilot project, in terms of diplomatic conversations with relevant government or ministries, but even when infringement proceedings are formally opened, very difficult to understand and to find that information. I think this also for question of accountability and transparency is extremely important. The notion of trust, yes, in fact in the study we highlight here the separation of powers too, in the sense how the accountability of the implementation of those rules, the Commission has the enforcement role, which often collides with the political role. So understanding the difficulty there of waiving political consideration with enforcement, checking precisely the evidence, still is responsible for upholding the treaties, guaranteeing that the treaties are upheld. And this is not systematically done in an area that lays at the very spirit of what the EU is. And it carries a lot of costs, indeed, in this respect. Is there any evidence? We found no evidence. I mean, even in the latest notifications, it's very broadly framed. I mean, it could be in terms of how the grounds justifying the internal border controls, the reintroduction, the prolongation, one would expect an increasing burden of proof as well. After 10 years, I mean, they may have some data saying, okay, this worked, this didn't work, I mean, at least something. 10 years. So, and we see nothing in the notifications. Perhaps the Commission has received other information on this, but it's not publicly accessible, and we didn't have access to this. And the last point on the economic impact, very important. And there was a European Parliament Research Service study on the cost of non-Schengen that was mentioned, that was done, and that it provides preliminary figures, important to update it, but also be mindful of the economic, very important, but the human dimension of the cost and the legitimacy dimension of the cost of non-Schengen could be more carefully also considered. Thank you.
Yes, please.
Oh, thank you very much.
I fully agree with Mr. Lopez Aguilar. I mean, definitely the new Schengen border code is an opportunity, and is even more than an opportunity, is an obligation for us to actually relaunch a process which should lead definitely with the termination of the current practice, which has been now to make regimes of internal border controls somewhat the norm, when it is supposed to remain the exception. This all the more so since Schengen doesn't evolve in a vacuum. I mean, Schengen is very much dependent on a number of other very important factors. At the very beginning of Schengen, the signatories of the first Schengen Treaty were extremely clear. The two conditions is on the one hand side, and that was Helmut Kohl's mantra, a form of European way of managing migration. And at the time, the whole issue was concentrated on the burden sharing. And for François Mitterrand, it was the security aspect, which led to a number of measures in order to organize and help cooperation at a European level. So now that we finally have, after many difficult years, a number of extraordinary reinforced ways to both improve the way we manage migration at European level with the Pact, it's a fantastic achievement, with further advances soon also on the return dimension, where we've seen also exceptional advances in terms of how we are actually capable of professionally managing external borders, with a number of elements that will still fully come in force, but the situation is dramatically different than a few years ago. And on the police cooperation as well, we see if there's still a number of legal impediments or organizational impediments, we see a totally different way between the police to actually cooperate and exchange information, etc. So the moment is there. I think the opportunity is there. The obligation towards us is there. However, if you press on us on the legal action, we do not have, and we have not seen in the past, a case for infringing in a member state on the fact that a member state would have triggered a clause of the Schengen Border Code allowing this member state to benefit from the possibility to conduct internal border controls. This is like the analysis of the Commission and the decision ultimately of the Commission. So we've acted through alternative ways. And we hope that with the Schengen Border Code and the new reinforced also obligations that fall on us, notably with the publication of opinion, we can indeed move a step further in terms of evaluating, questioning, and recommending another way to proceed. And again, if we see that border checks being conducted at different border crossing points have an effect, member states produce a number of figures, good examples also of what is happening, we are not convinced that this is the best way of organizing and getting these type of objectives. We believe that with enhanced ways of working with the neighbors in organizing enhanced security measures, the overall results would actually be much higher and not impede on extremely scarce resources, border guards, which would be better used at external borders, and we still see some deficiencies as external borders, than being employed in conducting sometimes formal checks at internal border points. This, I think, is a very strong demonstration we would like to achieve, both in the next State of Schengen report and in the forthcoming opinion based on the latest notification we will be receiving. On Germany, we see that there is a specific situation because of somewhat of a rigid way also to organize some of the controls. I mean, the colleague who was there early on mentioned in front of his house a border guard standing there forever. It doesn't make any sense. So we adamant in talking to Germany, trying to get the authorities also to accept the fact that the form of control need to change and be conducted in a more effective way. Cost of Schengen, very important. Very old estimates put the marker at about 1% of gross national income. In terms of the cost, it would fall if we would get out of Schengen. I believe this is much higher, much higher. We've seen some demonstration of that in the totally a disorganization of the logistics and economic way of working during the COVID time. We have just launched a very, very comprehensive economic study, and we hope at the end of the year we'll be able to provide better substantiated and objective figures on the actual real consequences of not having Schengen, and also some of the consequences of some of the remaining measures that are still in place in terms of internal border control. So for us, the absolute priority is to continue really holding the hands of member states, trying to get them to ultimately, formally and finally switch totally from former border controls at internal border to much more effective cooperative means with their neighbors in order to care for enhanced security in the Schengen area. Thank you.
Bardzo dziękuję panu.
Thank you very much for this response. Let me now give the floor to the chair of the working group on Schengen and border security, Madam Lena Dupont. The floor is yours for the next 10 minutes.
Well, thanks, Mr. Chair, and thanks also to the Vice Chair of the Libe Committee who had been with us here throughout the hearing. Let me first of all thank all the guest speakers here today and also connected online for their valuable contribution to that hearing, but also, of course, to the Commission present here in the room, to the members of the House here in the room, really addressing very concerning and very key issues of Schengen. Because I think it's safe to say that by the beginning of the year, we had kind of 3 days in one. We had one day to celebrate the enlargement of Schengen, a very crucial step, a needed step forward, a very much welcomed step also here in the House, not only for the 2 national delegations, but of course for the citizens of those countries. It was at the same time a day to take critical stock of where we are with Schengen, because I think it's safe to say that Schengen has been in a better shape so far, and that we urgently need to address what needs to be done to come back to Schengen in full life, so to say. Which leads to the kind of 3rd day in one, which is roll up our sleeves and actually start working on the reasons why member states do see the need to put up internal border controls again. What we've seen today here in the hearing is a comprehensive overview, a bit of a where do we come from, where are we now, with, of course, the very valuable contribution on the historical significance of the Schengen Agreement, the enlargement, and, of course, the Schengen Border Code that we just revised also here in the House, which shows that, again, Schengen is a bit of a living area in a sense of we achieved a lot, but we cannot take it for granted, and we need to make sure that it is an ongoing process and that we further future-proof Schengen as it exists right now. The second panel, of course, was the part of the critical assessment, highlighting again why it is so important that we take stock of where we are at Schengen now, that we further put more emphasis on enhanced cooperation, that we invest in trust, not only between the member states, but also in between the Commission, this House here, and the member states. And it again highlighted how we also reacted in times of crisis, when Schengen was under pressure in the COVID pandemic, but also, of course, now. So I think the main message that goes out from this hearing here today is that Schengen indeed is one of the greatest achievements that we have as European Union. It's kind of our DNA as European Union, but it is under threat, and we need to make sure that the reasons why member states opt for the reintroducing of internal border controls are addressed in a way that member states get a kind of off-ramp to then go back to a fully functioning Schengen as we had seen it previously. And I think at the very heart of it, of course, is cooperation, the mutual trust and the commitment of every actor involved in that area, which means also we need to address the very much reasons why member states opt for the reintroduction of border controls. And I think that the Schengen hearing today here highlighted not only the necessity to do so, but the needs and the means to do so. And I can both say to the Commission, but also not only here to the House, but also to the member states, rest assured that the Schengen and Border Working Group will follow up not only on the hearing, but of course on the very important topic of the functioning of Schengen as such. And with that, I thank everyone who had been participating in that meeting today, shared their insight and their contribution and their criticism, much needed criticism from time to time. And I'll conclude the hearing for now. Thanks.
Tak, ze swojej strony też bardzo pięknie dziękuję.
Yes, thank you. I would also like to thank our experts. I would like to thank the MEPs who have been with us during this hearing. You have asked very important questions. I believe that this was a very important discussion for the European Union because as we talk about the Schengen area, I do agree that this is a part of our common DNA for the European Union. I hope that we have managed to clarify some issues. Some are still to be clarified. Thank you once again for this meeting, and I declare this part of our meeting closed. And all the MEPs are welcome to the part of the Petty Committee at 4:30 p.m.